Really appreciate it. Yeah, my name is Steve Whitehorn. The name of my firm is Whitehorn Financial Group. We're also the creator of a consulting practice called the AE Empowerment Program. And what that is about is really to help our clients create a more significant legacy, and we empower them to achieve greater impact on their projects, on their relationships, and their communities. I'm going to be talking to you today about a general risk management program, general risk management idea. The concept is that you don't have to know everything. In fact, if you know everything, you don't need me. However, what I do want is that if you can create a sense of clarity, if something doesn't feel right, doesn't look right, doesn't sound right, say something. That's the best defense. A good offense is a great defense. We work with about 160 design firms, only architectural firms and engineering firms. Most of our clients, I'd say, are anywhere from about 15 employees to 150 employees, although we have a couple of clients in the 500 range. I'd say that's more the exception than the rule. Our clients do everything. I mean everything. You look around in any city, in any suburb, whatever it is, our clients design everything. I don't want to say we've seen everything, but we've seen almost everything. There's always something new, unfortunately, because of the lawyers. Nonetheless, the idea is to create a sense of anticipation in terms of what you're doing and why you're providing your services. The other thing I'm going to say is that I'm going to talk about me for a moment. We have technically 3 offices now. We have an office in Manhattan, New Jersey, which is our headquarters, in northern New Jersey, and also in Center City, Philadelphia. So really today, I'm going to be talking about really 3 major concepts, okay? The first concept is something that we call the standard of care. That's very important. It's probably the most important concept that I'm going to talk about today and probably in the future. Second concept I'm going to talk about is I'm going to talk about the legal context in terms of how does someone make their problem our problem? And if they sue, how do they actually end up proving, if possible, that we were at fault? I'm going to talk about that concept because it applies not only to the construction industry, it applies to every kind of any kind of lawsuit that would happen out there in the country. And finally, I'm going to talk about job site safety. And if I'm invited back at some point in the future, we can talk about the construction phase in terms of what your responsibilities are. We can talk about contracts. Let me see some smiles. Contracts, right? Contracts. We love contracts.
Yay,
contracts are friends, right? And we have a whole host of different programs that we can do. I'm actually not here to sell anything, as Steve was saying. It's really about you kind of figuring out why are we doing something? Because you may have been trained, oh, thank you very much. You may have been trained or taught to provide services in a certain way, and that's great, but I'm going to help provide a sense of clarity so you really understand exactly why you're doing what you're doing. Okay, so the first concept is called the standard of care. The standard of care. Now, the standard of care is extremely important because the standard of care is a concept that the law uses to judge whether or not a design professional or any individual is at fault. Okay, can anyone tell me how would you define the standard of care? Bueller? Go, yeah.
It's something I think about what other professionals do with equal qualifications in the same situation.
That's exactly right. And what is your name? Matt. Awesome. The standard of care is what another design professional would do in a similar situation. Okay, now can anyone tell me how the standard of care is actually defined? Like if you were being sued? Anyone? What do you think? Because this is the thing, okay? If you had a dictionary, we opened up the dictionary, you wouldn't actually see Steve's face in there. Who here has ever seen the show Matlock? You know Matlock, my guy's always innocent, right? This is what happens, okay? Matlock is defending someone. And what he does is he hires someone called an expert witness. And the expert witness would take a look at the situation, and the expert would say, this is exactly what another design professional would do in a similar situation. Now, the plaintiff, they would have an expert. Can anyone tell me what that expert would be called? The hired gun. Okay, that's a joke, okay? So they have the higher gun, okay? And so that expert would say this is not what another architect or engineer would do. They would do this, and therefore they were in breach of the standard of care. Now, it would be up to the judge and jury to decide, do they believe the defense, that yes, we met the standard of care, or do they believe the plaintiff? We did not meet the standard of care, therefore at fault. And whatever they decide, that determines whether we're in fault, or whether we are at fault. Now, if ultimately we're deemed at fault, we're in breach of the standard of care, can anyone tell me what that concept would be called? If you're in breach of the standard of care, you are deemed...
Loser.
Yes, yes, loser. You're deemed negligent. And so that's actually the concept of negligence. You're in breach of the standard of care. Standard of care for an architectural firm is what another architect would do in a similar situation. For an engineer, what another engineer would do in a similar situation. If you breach that standard, you are deemed negligent. And actually, that's what a professional liability policy covers. It covers negligence, no more, no less. Now here's the thing about a design firm. When we talk about the standard of care, believe it or not, the law says you are not perfect. My wife says I'm perfect, but I'm not perfect, okay? And believe it or not, you are not supposed to be perfect, because when you put together your documents show what it's gonna look like. The contractor, though, says how I'm gonna do it. So when we talk about the standard of care for a design professional, typically, it could be anywhere from 3 to 5% where it's assumed that there are going to be errors and omissions, coordination problems, so forth and so on. Now, if we talked about the standard of care for a contractor, can anyone tell me what you might think the standard of care for a contractor is?
There isn't one.
Perfection. But I've never seen a perfect contractor, I can tell you that, right? Perfection. And can anyone tell me where you would find the difference between our standard of care and a contractor's standard of care? Contract, exactly. Because our contract for an architect or engineer is going to say, we'll provide services according to the applicable standard of care. Now, the contractor's contract, can anyone tell me what that's going to say? It's going to use certain words. Where's Matt? It's going to say, we guarantee and warrant that we can build it in so much amount of time, so much quality for this amount of money it's going to take, whatever. They actually use guarantee and warranty. That's a contractor standard. We show what it's going to look like, and they say we have the means and methods, techniques, sequences, and safety procedures guarantee to actually put it together. It doesn't always happen that way, but that's actually what the contract says. Okay? Am I clear about that? So the standard of care for us is not perfection, but it's without question your responsibility to manage the owner's expectation in terms of the standard that you're going to provide. Because as time goes on, okay, you design a project for 6 months and it's under construction for 1.5 years, right? As time goes on, that owner's expectation is going to change. Can anyone tell me why you think the owner's expectation is going to change from the beginning to the end of the project?
Money.
Money. Exactly. What happens at the end of the project?
There's no money.
There's no money, right? And so what happens is the owner is, oh my God, there are all these problems, and who's going to pay for it? Here's the issue. Design professionals are the only firms or entities in the construction progress that actually has any money because of the insurance policy. The owner has lots of insurance. The contractor has lots of insurance, except those policies don't cover faulty workmanship. So you say, okay, we're going to put these windows in, and the contractor doesn't do a good job. They don't have coverage for that. So what's going to happen? The contractor is going to point the finger at the design firm and say, you know what, they made a mistake because they didn't detail it properly, because this and that. You see what I'm saying? There are only 3 things in life you can guarantee when you come to construction: death, taxes, and change on a construction project. You have to remember, at the end of the project, the owner has no money. The contractor's motivation is money. Our motivation is quality. So clearly, they are going to turn to us. And so managing the owner's expectation in terms of we are not perfect, providing a sense of anticipation or transparency, even up front, saying, you know, these are the kinds of issues that we can run into. and talk about them. Because if they happen, the owner is not going to point the finger. They're going to say, well, how are we going to deal with this? And they will find the money to deal with it. It's about relationship as well, managing expectation and relationship. I always say to our clients, people don't sue because you make a mistake. They sue because of a lack of relationship. If you're losing the relationship or you lost the relationship, everyone is going to lawyer up. And when they lawyer up, it's incredibly expensive. Okay, any questions so far? The standard of care. You will provide services based upon what another architect or engineer would do in a similar situation. It's about relationship, and it's about managing the expectation of the people around you. So that's the standard of care. So I'm going to move on.
Before you move on,
Yes.
you're making the assumption that we know what another architect would do and what those standards of care is. Is that written anywhere? Is that documented anywhere?
It is not written anywhere. It is not a document. It's up to the expert witnesses to establish whether you have met the industry standard or you have not. And so you hope that the people that are defending you and the experts are not only convincing, but they are qualified and highly credible. And that's what you hope for. And the legal system is not always fair.
So how do we learn that up front as we're doing our design?
The only way I can say this is that if what you are doing you feel meets or possibly exceeds what the industry is doing, there's nothing wrong with telling your client, you know what, this is what we're doing, and you're transparent about it, and telling them this is what we did and why we did it. As long as they have this understanding and transparency about what you're doing and how you're doing it and why you're doing it, and it doesn't necessarily mean they want to know everything, because quite frankly, your clients don't want to know everything. But as long as they understand the part of the process, they will probably believe, without question, that you're meeting the standard of care. That is if you have a good relationship. Who here has ever had a bad client? Of course. We've all had bad clients. I fire bad clients. I don't like doing it, but we do it. Because, I'll tell you why. Because if you have a bad client, no matter what you do, you are never going to meet their expectation. Doesn't matter how hard you try. Doesn't mean if you spent 3 times what was in the budget to provide a service or to do whatever it was. It doesn't matter. A bad client's a bad client. And that's unfortunately the way it is. So I think there is something to be said about, of course, those people who are licensed, you're licensed because you have the qualifications. But also making your client part of the process as opposed to just providing services in a vacuum. I think that really, that manages the expectation, but also I think it becomes more clear through whatever you're doing that you are truly doing what you say you're going to be providing. Okay? Any other questions? Yes?
So earlier you said both the defendants and the plaintiff hire the same expert to prove.
They hire different experts.
But they are in the same industry.
Yes.
So, but it's up to the judge to say who follow the standard.
Excellent question. There are actually 3 different venues for dispute resolution. Okay? The first venue is something called mediation. Okay? And so there's a mediator. It's not really a judge. And usually it's not a judge. It could be someone that's from the construction industry, and that's typically what we do. And some of your projects, if you look in your contracts, there's a section on dispute resolution. Okay, well, if there's a dispute that's under $100,000, you go to mediation. And mediation is considered non-binding, which basically means that everyone can sit around, sing kumbaya, and then walk away. Okay? So anyway, so in that kind of scenario, both the defendant and the plaintiff will each have experts. And they will analyze whatever had happened, whatever the situation is, the roof is leaking, water's coming through the windows, whatever it is, and they'll say, well, this is why it happened. And hopefully they'll come to some kind of resolution. So that's mediation. Arbitration is basically one step further. Okay, arbitration is typically what we will find because once again, you're dealing with the construction industry, arbiters. They don't have to be lawyers, they don't have to be judges. And typically what that means is that once again, they understand the construction industry. Most people believe that architects are the master builders. If you're going to do addition to your home, who do they call first? It's disgraceful. They call contractors first. Horrible, right? But the point is, most people really don't know what an architect does, or an engineer does for that living, for that matter. So, so in arbitration, it's binding, which means you sit around, you go through, you have your expert and your report. Same thing, the plaintiff, they have their report, and whatever is ultimately decided by the arbiter, that's it. And you cannot go back and try to reopen the case, appeal it, excuse me. Then there's a third venue, which is actually the judge and jury. Okay, and it's really, that's a jury trial. Now the thing is, when you sit in front of your peers are not your peers. Those peers are not my peers. We know that, okay? So when you have a judge and jury, it's actually the jury that decides whether there was a breach of the standard of care, that whatever the dispute is. The judge is the one that's giving the directions, right? And they're kind of orchestrating what's going on and who's going to speak and what is considered allowable versus not allowable. But once again, they're experts on the plaintiff side, on the defense side. And it's going to be the jury that ultimately decides who they believe. Okay? Any other questions? No. Okay. So what I want to do, I want to talk about the legal process, the context of claims. Because when you understand this, it's actually kind of interesting. Now, has anyone here ever been in a lawsuit? Okay, a couple people. Okay, this is what happens. Now, our legal system is based on something called common law, which goes back to 600 AD, back in England. Common law is not written down, okay? But ultimately, it's the kind of thing where it's practical. If Steve is on a ladder, I knock him over by accident, he gets hurt, I have to make him whole. That's common law, okay? So this is what happens. In our legal system, based upon common law, the plaintiff has to prove 4 things in order to be deemed at fault. If they can only prove 3 of them, we're not at fault. They prove 2 of them, we're not at fault, okay? So the first is that there's a duty. The second is that there's a breach of that duty. The third is that there's causation. In other words, we were the proximate cause of whatever happened. And the fourth is damages. Who here likes my handwriting? No, okay, it gets worse as time goes on. That's why I don't write too often. Okay, so this is what happens. The plaintiff, whoever it is, no matter what it is, they have to prove 4 things. They have to prove, number 1, that we had a duty. Number 2, we breached the duty. Number 3, we were the proximate cause of that breach. And 4, there were damages. Who here has ever been driven through a red light? Who here has ever driven through a red light and never gotten caught? Exactly. Okay, so let's take that situation. Number 1, did we have a duty or responsibility to stop at the red light? Yes. Did we breach that duty? Yes. Were the proximate cause? Yes, because we were the ones that went through. Were the damages? No, because we didn't hit anyone, we didn't get a ticket. Exonerated. Same situation, but this time you hit a car, $5,000 of damage, no one's hurt. There's a really funny joke about that. Actually, the one about the rabbi and the priest. Never mind. That's some other time. Okay. It's really funny. Anyway, okay. So you go through the red light. You hit a car, $5,000 of damage. No one's hurt. Did you have a duty to stop at the red light? Yes. Did you breach that duty? Yes. You're the proximate cause. Yes. Damages, $5,000. You're deemed at fault. You breached the standard of care. Same situation. Clyde and Mars did an adaptive reuse project in Atlantic City, and it was like an old warehouse making into apartments, okay? So we decided he's gonna put windows in, but he decided not to put a window detail on the outside of the window. So guess what happened? It leaked, okay? So it caused something like $175,000 worth of water damage, and of course they had to pull the windows out and everything else. So here's the question. Did my client have a duty to design a building that didn't leak? Yes. Did he breach the duty? Yes. Approximate cause? Yes. Damages? I think ultimately he paid about $175,000 and he had about $100,000 in legal fees. To defend that situation, he did not put the window detail in. Now, let's assume, same situation, my client put the window detail in, but the contractor didn't construct it properly. So my client, architect, did he have a duty to design a building that didn't leak? Yes. Did he breach that duty? No, because he designed it properly. Let's take a look at the contractor. The contractor put the windows in improperly. How often does that happen? How often does like the skeleton of a building leak? All the time. It's not because of you're designing it, it's because of how it's installed. Okay? But our clients are always involved, because there's always this, well, you know what? This guy, my clients have the deep pockets. Well, we didn't install them properly. It's because it was designed improperly. And those kind of disputes happen all the time. So let's take a look at the contractor situation. He put the windows in improperly. Did he have a duty to build according to the specs? Yes. Did he breach that duty? Yes. Approximate cause? Yes. Damages, $175,000. So irrespective of what kind of dispute, if a tree falls on the house next door, right, or it's a car accident, or it's a construction related issue, which by the way happens all the time, I mean all the time, this is what the plaintiff has to prove. Now I want you to think about this. Imagine you have a construction site, okay? Someone's walking by. The contractor put a fence around the construction site, right? Contractor's walking by, they trip and fall. Your contract always says you're not responsible for site safety, solely the responsibility of the contractor. The plaintiff, the person that tripped and fell, they don't know that you're an architect, or rather, they don't know that you don't have responsibility for site safety, but their attorney is going to try to somehow establish the fact that you had a duty or responsibility. That's what they're going to try to establish. And it's going to be our job, or the attorney, I think you use Gary Chimento, right? So it's going to be Gary's responsibility to say, well, look at our contract. It says we're not responsible for site safety. But they're still going to try to bring us in and establish somehow, and we're going to talk about that, I'll give you examples, that we had a duty, that we breached the duty, that we're the proximate cause, and that ultimately we were responsible for the damages. Okay? Any questions? Yes?
You were talking about the incidents with $175,000 worth of damage.
The windows, yeah.
Okay, now, in a situation like that, is there, I think of it, yes, it's our duty to design things that don't leak and et
Yeah.
cetera, and the documentation and everything. But is there also not a responsibility on the contractor saying, okay, this guy's installed X number of windows over his 20-year career or whatever? I mean, isn't there a little bit of evening out there? Is he responsible at all, or is it all?
Let me say this. If a contractor has done 500 projects that have windows in it that are of similar nature, you would think that the contractor would say, and look at the drawings, when they saw the drawings, say, you know what, there's no window detail here. Absolutely. Doesn't always happen. And so the lion's share of that, the vast lion's share of that responsibility is on the design side, because we do not meet the standard of care. I'm going to take my jacket off. The other thing is, I want you to think about this. Now, I know you don't, I'm quite certain you don't get involved with public projects low bid, right? Do you get involved with low bid? Some? Imagine a contractor actually saying to you, oh, by the way, you didn't put the window detail in. You know why? Because they're going to put the windows in, then it's going to leak, and now, if the windows cost $175,000, it's now going to cost $500,000 to take the windows out, put the detail in, and then put the windows back. Change orders, right? Because if a system was going to be bid from the first day, let's assume the system's going to cost $100,000. Now, if it's a change order, it's now going to cost $250,000. So, especially in low bid scenarios, they are looking for change orders in the change order game. So, but yes, I would agree with you. The contractor should have some accountability, but most of the time they're not. They're going to say, look, your drawings are not correct. We just built what's on the drawing. What do I know? I'm a contractor. That's what they're going to say. Yes, there's another comment.
Not every project is detailed to the same level because of our fee or for another number of reasons. So for like small fee projects where you don't have as many details, do you open yourself up to more liability?
Absolutely. I'm going to give an example. We have a really ugly one going on right now. Okay? Our client was an architect, is an architect, successful architect. He was hired to design 142 units of townhouses in New Jersey. Okay? I live in New Jersey. Kind of corrupt New Jersey, but I live in New Jersey, so I understand. I'm not saying that. Okay? He was hired by the one of the top 5 developers, residential developers in the country. He was hired by the developer to provide a set of builder's plans, which basically means they're not detailed. Okay? Now, the developer also had a construction arm. And so his construction arm was going to build these units. And the thing is, the units were not built well. There's like $20 million worth of damages. And the developer who hired my client, and the contract was very specific about builder's plans, the contractor came back and said, you know what? Okay, you gave us builder's plans, but we want you to pay 10%. 10% of $20 million is $2 million. Okay? So the insurance company has set aside $1 million for this situation. Everyone, all the other plaintiffs, because now you have all these residences, right? Unsuspecting people that own these units, they're saying, but my building doesn't work. My building leaks and this and that and all kinds of stuff. Like the outside of the building, you know how you're supposed to shingle from the bottom up, so to speak? Well, they did it from the top down. So when it rains, the water gets in. Can you imagine that? My client had no CA services at all. Now, let me say this. He's reserved for, the insurance company put aside $1 million for the situation, builder's plans. All the other attorneys are saying, but he didn't meet the standard of care, didn't meet the standard of care. His contract said, I didn't have to meet the standard of care. But meanwhile, the insurance company thinks that they're gonna have to settle it for $1 million. I hope it's gonna be way less. It shouldn't be anything. But the only good thing that has come out of this is that he pays a fortune for his insurance because the insurance company will pay a lot of money out. I'm gonna give you an example. He pays about 13% of his revenue for his insurance, okay? The only good thing about that is I have 3 girls and they're very emotional and very expensive. But there's nothing funny about, but literally, that's not good. So even though, yes, so you have to be careful. You have to be careful about who you're dealing with. If you have confidence in who you're dealing with and you have a relationship and it's kind of like, not only quid pro, but like yin and yang kind of relationship, it's okay, but you just have to go in with a sense of anticipation. So it definitely can be problematic. So now I tell all of our clients, please don't provide builder's plans. And if you want to, that's okay too, because I'm never gonna tell you what to do. It's your decision. But yes, it's covered. All this stuff is covered, okay? Any other questions or comments for the moment? Yes?
As you were talking, I'm thinking, why is it that contractors and construction companies don't protect themselves the same level as designers? I mean, why are they not required to protect themselves the
Okay.
same way as designers?
Well, let me say this. The protection that I'm talking about that your firm has, that they don't, that protection is not available to them. So in other words, if they went out into the insurance marketplace, they actually cannot get insurance that would give them coverage for faulty workmanship, for doing a bad job. Because probably the potential exposure that the insurance company would be taking on could be huge. And so it's a risk that's uninsurable. And contractors are very good business people. And they just have a way of weaving and bopping. And so you've ever heard like contractors, they all of a sudden go out of business and they come back in under a different name? You know what I mean? So it's like a whole different dynamic. And quite frankly, it would be good. It would be great if they did. But then what they're gonna say is, well, if we have to get this insurance, then we're gonna have to charge the owner so much more. So there's a huge risk involved with design and construction. The owner's taking on a risk, hoping that they're the right design team and the right contractors, right? And they're not gonna run out of money, which they typically do anyway, by the end of the project. The contractors have risk because they have to build it, and their motivation is about profit and money. So they wanna build it as least expensive, the lowest common denominator as possible. And then we have the architects on the other side, and the engineers, and we're about quality. We wanna design it as well as possible. You ever notice that like, you presumably, I'm sure you're tracking your budgets on your projects. During design, you're on budget, everything looks great, but during construction, all of a sudden it blows up, your budget. Why? It's because you're trying to make sure that the quality that's supposed to be there is gonna be there for the owner. You're trying to protect the client. And it's difficult to get paid extra when the client doesn't really understand the value you're providing. So, and we're gonna help change that. We're gonna help change that in terms of putting you in a better position of strength, so that way during construction you'll be able to control the flow of information, which means you'll be able to control the accountability that the contractor is taking on. Not necessarily an easy thing to do, but it can be done if you're willing to have the confidence to do it, okay? So let me just move on here. All right, so we talk about these 4 things, As a design professional, your duties or responsibilities come from 3 sources. Can anyone tell me one of the sources? Where would you find your responsibilities?
Contracts.
Exactly. Your contract. Contracts are your friends. I said it with a smile. They're your friends. Because the contract articulates who's responsible for what. Now, in your own mind, I don't want to see hands. Who here has read the contract for each of the projects they're currently working on? Okay, I know. It's okay, everyone take a deep breath. Okay. Remember, the contract is going to articulate what that box looks like in terms of what your responsibility is, not just the scope, but also in terms of what you're providing. I'm going to give an example. If you look at the construction phase of a project, there is going to be a section that says construction phase. It talks about submittals. One of our clients, very well-respected landscape architectural firm in New York City, they're working for an agency. And when it talked about submittals, it said that they will review the submittals with respect to the design intent found in the construction documents. And they're going to review the submittals with respect to the contractor's compliance with ADA. Whoa. That's a red flag. We never want our clients to be responsible for what the contractor is doing. The contractor is always responsible for what they do. But because it's a public agency, they were not able to negotiate out of the language. So the idea is that if you read the contract, you're developing a sense of anticipation. What are we supposed to be doing? Because if you were supposed to review the contractor's compliance with ADA, and you didn't, and the contractor did not comply with ADA, the plaintiff, the owner, is going to say, did you have a duty or responsibility to review the submittals with respect to ADA compliance? Yes. Did you do it? No. Did you breach that responsibility? Yes. The proximate cause? Yes. Damages. ADA can be very significant damages, okay? But there are all kinds of subtleties in each of your projects. If you are using what we would call a standardized contract, either your firm's standard contract, or like an AIA-based contract, like a B101 or 103, right? It's all the same with exception of the scope and where it's located in the project and so forth and so on. But your responsibilities in terms of submittals with respect to site visits, with respect to what you're doing in schematics and DDs, schematics and DDs and CDs, they're going to be very consistent. So if you see a separate or different kind of contract, I'd suggest you look at it, because there are going to be subtleties all over the place. And it's better to know up front as opposed to not know and then find out after the fact. Okay? Now, can anyone tell me a second source of responsibility?
Codes.
Absolutely. What is your name?
Steve.
I love that. I can remember that one.
Can't
Thanks,
forget
Steve.
that one.
I'm great with faces, not so good with names. Okay. So, codes and ordinances. That's right. Okay, so as a licensed professional, you have a responsibility to design some codes and ordinances. They're considered the minimum threshold. You can always design higher, you can't design lower. You design lower, bam, you're at fault. Insurance pays. To do whatever it is to make it right. So codes and ordinances. Can anyone tell me a third and the final source of responsibility? Especially in New Jersey. Actions. Your actions. It's possible that through your actions, you are taking on responsibility. Let me give an example. About 9 years ago, we had a very, very, very famous architectural firm. Really famous. Happens to be based in Center City, Philadelphia. Okay? They were doing the restoration of a building at University of Pennsylvania. And what happened was, there were 2 spaces, and there was a threshold in between these 2 spaces, and there was tile that was put there. Halfway through the project, Trammell Crow, who was the CM, was fired. So my client, the architect, stepped into the role of the CM and started directing all the subcontractors. At some point in time, a tile fell from this threshold, hit a woman in the head. She collected $1.2 million. My client was responsible for $475,000 of that. $275,000 of legal fees, because through my client's actions, they were taking on the responsibility of site safety by moving people around and telling them what to do. Their contract was very specific. We were not responsible for site safety. That's solely the responsibility of the contractor. Through their actions, they took on that responsibility. We have another client out of New York, really famous traffic engineer. Okay, I mean, he's all over the place. You see him in the media and all this kind of stuff, right? Well, there was a roadway, okay, 2 lanes. Anyone know what a traffic engineer does? They count. They count, okay? So the guy's standing on a corner, and he's counting the number of cars that are going by, right? Now, halfway up the block, there was a contractor that was basically gonna make the 2 lanes into 1 lane, and so he was putting up cones and signage. And my guy, who's on the corner counting, walks over to the contractor, and he says, you know what, I think you should do it this way. Maybe not that way. Okay, great. So he goes back. An hour later, this guy on a bicycle, it's a horrible situation, is going from a 2-lane road to a 1-lane road, and he's run over by a truck. The guy will never be the same. Never be the same. He's going to end up, in fact, it's about to get settled right now. He's going to end up getting about $20 million. My client had $2 million of insurance. That insurance is gone. There are other parties. There's the city of New York involved. There's a contractor involved, so on and so on. But through their actions, they took on the responsibility. So you really want to know, what does that box look like? Are we doing what we say we're going to be doing? That's why our contract's your friend. Any questions so far? One last thing. When we talk about this, it's always the small stuff that creates the biggest problems. You ever hear like the 80-20 rule? You know, like 20% of your aggravation, 80% of your aggravation comes from 20% of your problems. It's always the small stuff that's going to create the biggest aggravation. I'm going to give an example. Okay? About 10 years ago, we have a client. Okay? They do like industrial type stuff, engineers, mechanical and structural. What they did, what they were asked to do, was they were asked to design the piping from these industrial vats, okay? And that circle that represents, I know it's not to scale, it represents a damper, okay? So they were paid $1,500 to design the piping, inspect the damper. Now, what's supposed to happen is a truck is supposed to back up with number 5 fuel oil waste and dump it into the vats. And then the elements sift off one by one and everything's great. The problem was that instead of dumping number 5 fuel oil, some yahoo dumped number 7 fuel oil. They had the biggest explosion you could possibly imagine. The EPA came in, fined the owner $2.5 million. The insurance company for the owner came in. They fixed everything and paid for everything. And then they subrogated against anyone that was involved. What that means, it's a fancy word of saying, that's when an insurance company says, my guy didn't make a mistake, we're gonna get the money back. So they sued my client, and they sued the manufacturer, and so forth and so on. Now, what happened was, the damper that was spec'd was not available. And so the manufacturer said, oh, you don't have to use this one, you can use that one. This owner was one of my client's largest clients, my engineering firm's largest client. So they were there once a week. They never went back to see what was done. They didn't have CA services, but they never went back. The plaintiff, which is the insurance company, said, but you know what? Since you're there every week and it's your biggest client, don't you think you should have at least taken a look? And because of that, remember, the plaintiff doesn't care whether or not you really have a responsibility. They just want to establish the fact that you had a duty of responsibility. They don't care. It's about money. So once they establish the fact, well, you breached that responsibility because you're there once a week. They ended up paying out $475,000. The legal fees were something like, $1 million policy. The legal fees are about $300,000. They had $25,000 left in their insurance. Horrible situation. It can happen. So the point is this. When you're doing a small project, everyone take a breath, deep breath. It's okay to take a step back and say, you know what? Something doesn't look right. It's okay to say, you know what? Maybe I made a mistake. I'll tell you why. Because if you see the mistake and you bring it to someone's attention, you can do something about it now. Because it costs so much less money to do it now as opposed to after the fact. When I'm talking about these windows, right, and the window detail, it would have cost like $20,000 for them to have pull the windows out and put it back in, or notice that it wasn't there, 20,000 as opposed to 175,000, and then another 100,000 on top of that. Here's the other thing, when you talk about legal fees, imagine a client, a firm spends $100,000 defending themselves. What that means, the industry metric is that it takes 3 times as much of your time that's not billable for every hour that the attorney puts in defending your situation. So if you recognize there's an issue, say something. Your client is not going to be happy when it's brought to their attention, but I'll tell you this. They will be thrilled after the blow up. They will be thrilled knowing that you are fully accountable for everything you're doing. And it's going to cost your firm a lot less time and money doing it now as opposed to after the fact. Okay? Any questions? Okay. So now I want to talk about real quick about what an insurance policy looks like. Who here loves insurance? Okay. This is really easy. Okay? This is really easy. Okay? Doesn't matter what kind of insurance we're talking about. An insurance policy looks like a solid piece of cheese. Okay? Cheese. They say, we give you coverage for everything under the sun. And they say, except. Okay? Except airplanes, automobiles, willful or intentional acts, because that's criminal, right? Here's a trick question. I want to see who's paying attention. They exclude guarantees and warranties. Why? It's not in the contract, but why do they exclude guarantees and warranties? Exactly, we're not perfect. So if we say the lights are going to turn on, they don't turn on for whatever reason, we have no coverage. So when you look at your contract, it's going to say we'll provide services according to the applicable standard of care as expeditiously as is consistent with the orderly progress of the work, that kind of stuff. But it's never going to say we guarantee. If you ever see the word guarantee, ever see the word warrant, ever see the word certify, red flag. Who here has ever heard of George Carlin? Okay, George Carlin, the 7 dirty words. When you think insurance, I want you to think dirty words. Guarantee, warranty, insure, assure, ensure, certify. Be careful. Now, you're going to be asked, yes?
Just for those of you that do see those, because we do a lot of certifications.
Yep.
A lot of them. And the next most dangerous word after certify is all. You'll see it, many of the things that we get from banks that we certify that it's compliant with all regulations, all this, all that. And you'll usually, when we find it, we will strike that out and say, to the best of our professional knowledge, understanding, and belief, because nobody's perfect. We can't know everything, and that's what that statement says. And if you sign something that says you know everything, we're not covered.
Exactly.
But it still says certification on top of it.
It's going to, but what's going to happen is you're going to change the language. I mean, like
Our
Steve
job is to
said.
poke holes in their certification.
Exactly, and I'm going to give you a couple of ideas, and you're probably doing this, but at least for everyone's benefit. If it says, I hereby certify it meets codes, that's a guarantee, no coverage. If you say, I hereby certify, in my professional opinion, you're changing a guarantee to an opinion. Okay? And there's one other step as well, and this is what Steve was saying, and that is this. If a bank ever comes to you, and I'm sure they come to you all the time, we want you to certify this and that, blah, 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 blah. Sometimes the certifications could be 1 paragraph long. Sometimes the certification could be like 5 pages long. And you might have language in there that says something like, it's supposed to, well, the original language as proposed says, I certify that at the ends of the project, the electricity will be hooked up. I want you to think about this. You are not responsible for the electrical hookup. That's the contractors, right? So when you see language, you always want to narrow it down to specifically what you provided. No more, no less. Because if there's a problem, the bank is going to say, did you have a duty or responsibility? Did you agree to this? Did you say you did this? Did you represent this? You see what I'm saying? So the language is always whittled down. We have a client in Center City. The firm is SPG3. The person that used to run the firm is a guy named Irv Shapiro. I don't know if anyone knows him. He's a business person that happens to be an architect, okay? Years ago, I remember this, I was having this conversation with him, and he was hired by Toll Brothers to to design. It was like a pool house for like a residential community, right? They didn't want to hire him to provide CA services. And then after it was all constructed, and so he only designed it, nothing else, they wanted him to certify that it met this and that and so forth and so on. He's like, what are you, nuts? You didn't pay me to do it. So be careful with language. Remember, to us, to most people, language is not important, but to lawyers, language is essential. Lawyers and attorneys, they can twist words in one way or another. So when we do with certifications, representations, you want to make sure it's narrow, based upon my professional opinion, based on the information available. Okay? So anytime when you look in your contract, because I know when we're done, you're going to go back and read every contract for the project you're working on. You're going to see if you see words that say guarantee, warranty, so on and so on. There are only 3 things that you can warrant or guarantee. That's it. You can warrant that you have the authority to sign a contract. You can warrant the fact that or guarantee the fact that you're licensed. And you can, which really isn't an issue, you can warrant the fact that your firm is solvent enough to provide the services. That's it. No other time we ever want to see that language. If you do, say something to someone. Now, our firm reviews contracts with respect to risk management and insurability implications. I'm not an attorney. Sometimes people think I look like an attorney. Sometimes I think we're in that bag, they think I'm an accountant, okay? I know a lot about that stuff, but the reality is we review contracts for our clients with respect to insurability and risk management implications. We want to minimize your risk, increase your profitability in terms of how you're providing services. We also have a law firm on retainer to our office that reviews all of our contracts. We're not a law firm, but not with respect to not respect to legalese, but with respect to risk management and insurability implications. Okay, so if you ever have a question, something doesn't look right, call us. I can assure you that we can help you. And if we don't know the answer, we will know where to go to get you the answer. Yes?
You were just talking about language, and I was thinking earlier you said if you recognize there's a problem with your documents or something that's going on the project, you should bring it to the attention because it's cheaper to fix at that point than later.
Absolutely.
Is there any certain language that you should avoid when bringing that problem to attention, or any language you should use?
Excellent question. This is the first thing I'm going to suggest. Without question, if you see an issue, say something to Steve, say something to Debbie, say something to the other principals as well. Because they're going to know and figure out what the best strategy is. At that point, they will probably bring us in. And we'll probably bring the insurance company or maybe an attorney to kind of give advice to making sure that we're very clear about what the most effective approach is. And so ultimately, when that is brought to the attention of the owner, it's going to be brought to their attention ultimately with kid gloves. And I wouldn't necessarily say that there's language that you'd use or not use, but I would just say that in general, approach it internally first, bring us in, maybe we can help you, or the insurance company because they have a lot of experience as well. That's really the best way to approach that. Okay, oh, and here's the other thing. Don't ever say to your client, oh, we made a mistake. Deal with it internally first. Always, 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 okay? Last thing I want to talk about. Any questions? Questions? Okay. Last thing I want to do, you know what? I'm going to draw a couple pictures first, okay? And you have to tell me what you think they are. This has nothing to do with risk management. Okay, you ready? I'm going to move out of the way. What do you think that is? A bear? A giraffe? It's actually a bear climbing a tree. Yeah, hugging around, right? Okay. Let me give one more. Okay. The first time I did it, of the 3 girls, my middle one at the time was about 14, and she loves this. What is that?
Tennis ball.
Close. Good guess. What do you think? It's actually someone looking down on my head. Okay. All right. Now, I was an economics major in college, okay? You get it? Okay. All right. Okay. I was an economics major in college, okay? So don't tell me It's supply and demand. I know. But tell me what you think it represents. Oh, hold on. Let me redraw this. It's actually out of scale. It actually is. Hold on a
We
second.
get that a lot around
I know. I'm all excited. Okay. Everyone see that? Okay. What do you think that represents? Supply and demand. Throw out a guess. Anyone? Kind of. Give me another guess.
Everything.
This actually represents the construction process, design through construction. This actually represents your relationship to the owner. Okay? Okay. At the beginning of the project, the owner loves you. What, you can't see that?
You don't know our clients well.
Presumably your clients love you. And how do you know they love you? They hired us, exactly. Okay, that's good. I like to start at the same place. Okay, they hire you. And you start designing and they're paying you and your fee is significant. Generally speaking, your fee is gonna be 80% on the left until it goes to the construction. That's the way the AIA documents are set up, right? But they love it and you're designing. They say, oh, this is great. And they may have an idea, say, oh yeah, that's really good. They may have something else, say, no, how about this? You say, no, we don't want to do this because it's so and so on. Everything is great. Presumably they're paying you. Presumably. That's really important, okay? Now, in the beginning, you typically don't even know who the contractor is. On most projects, at least with a lot of our clients, okay? So your relationship with the owner is great, and the contractor has no relationship with the owner, right? Then the contractor comes on board. The first thing they do, they put up a fence. Why do they put a fence up?
Staking out their territory.
They're staking out the territory, and what's really happening is the owner is handing over control of the site, okay? So now the contractor puts a fence up, controls the site, and they start building. And as they're building, remember now the owner's really running really big checks, right? And what is the contractor saying? The architect doesn't know what he's doing. The architect costs you so much more money. We could have saved you a couple $100,000 on that. You see what I'm saying? And as time goes on, your fee goes down. It's little by little, you're going out to the job site, the appropriate stage of construction, once a week, whatever it is. And so your relationship is becoming more and more and more distant with the owner. But the contractor's relationship is getting better and better and better and better. And by the end, the owner just wants to get rid of everyone, right? So what's happening is, it's about influence. There's a shift in influence in terms of relationship. Remember I said people don't sue because you make a mistake? They sue because of a lack of relationship. This is where our clients are most vulnerable. So the idea is that you have to constantly poke the owner. Poke the contractor. Now let me say this. We are not always going to be perfect. The contractor's not always going to be perfect. It would be great to have this kind of yin and yang relationship. But you have to continue to poke them. Because when something comes up and the contractor says, we could have saved you $300,000 on that, you're in a position to say, well, you know, we talked about that. And the reason why we decided not to was because of X, Y, and Z. It's about relationship. People don't sue because you make a mistake. They sue because of lack of relationship. So if somebody calls up the office, and you hear this tension in their voice, you have no idea why. Maybe it's a bad day. Say something to someone. If the contractor typically emails you a response in 2 hours and it takes 2 days, say something. Because you may not know why, something is going on in the dynamics, but if you say something, someone here will figure it out. Because if the owner is unhappy, you want to do something about it now, not after the fact, because it costs so much less money now. When everyone lawyers up, it costs a huge amount of money. And also remember, don't think about the job you're working on, per se. Think about the next job. How are you going to get the next job, right? So think in terms of, you want to be responsive, you also want to be accountable, but say something internally, because it's about relationships, okay? Last item. Any questions on that? Okay, last item, I'm going to talk about job site safety, okay? Now, all your contracts, all of them, are going to say the architect's not responsible for site safety. That's solely the responsibility of the contractor. They're all going to say that. However, I want you to think about this from a very practical perspective. If you see imminent danger, do something about it. Imminent danger, there's a ditch and a guy's in the ditch 10 feet down, do something about it. If you see a hole in the floor, imminent danger, someone right there, do something about it. It is not your responsibility to go around with a badge, but imminent danger. Because if you go and you see someone in a ditch, get out of the ditch, your next move is you're gonna go to the foreman and you're gonna say, I saw an unsafe site. This is your responsibility, you need to do something about it. And then you're gonna write the owner and you're gonna copy the contractor. Can anyone tell me why we would write the owner?
That's what you have a contract.
Right, and it's their site. Because if someone gets hurt, the owner is gonna end up paying something. Exactly. Okay? So only imminent danger. That's the only time you ever wanna have anything to do with it. We've had all kinds of crazy things where our clients have been dragged in because they didn't do something. And they end up paying because they didn't do something. It happens. The other thing I do wanna say though, very specifically, is a lot of your projects, maybe half your projects are in New Jersey, is that correct? Give or take?
Maybe a little less.
Okay. New Jersey is very specific. New Jersey says if you recognize danger and do nothing, you're responsible. That's what New Jersey says. If you recognize and do nothing, you're responsible. In Pennsylvania, they say you have no responsibility no matter what. In New York, anything can happen. Anything can happen. All right. The other thing is when you go to the site, make sure you're dressed appropriately. All right. You don't wear a tie, wear boots, jeans, wear a hard hat. Follow the rules. You are a guest of the contractor when you go to the site. We never want anyone to get hurt. Doesn't happen often, but make sure you're dressed appropriately. Okay? Are there any questions? Yes.
You say do something, but isn't there things that are appropriate and things that are inappropriate as far as what you do?
The only thing that should be done that I've seen, that I've been instructed over the years, is that imminent danger. If you see an unsafe site, get that person out of the ditch, get them away from the hole. If you happen to see something that doesn't look right and something that's really kind of dangerous and no one's there, you could say something to the foreman, but I would bring it up in the next meeting saying, I saw an unsafe site. This is not a responsibility. This is the sole responsibility of the contractor, and they should be addressing it. But beyond that, we really don't want anyone walking around looking for things that are out of whack. Because if you're on the 5th floor and something happens on the 1st floor, you have no responsibility. You're not even there. Clearly, you have no responsibility for site safety. But imminent danger is the trigger. Imminent danger. And try not to go beyond that. It's kind of the moment. And I hate to say it, but that's the most practical advice I can give you. Okay. Any other questions? Yes?
Back to contracts.
Yes.
Have you ever come across in the AE field, or at least in architecture any other contract forms besides the AIA?
Of course. Yeah, the AIA,
I'm just wanted to, because we just come up against that with a client of ours.
yeah, they're,
Totally different, based on the AIA form, but slightly different.
yeah, there's, let me say this, the AIA, from an architect or engineer's perspective, is the most fair allocation of risk and responsibilities between all the parties involved in the construction process. Okay? Now, owners and contractors say that the AIA is slanted towards architects. You have something called a consensus docs. Okay? Okay, now consensus docs are based on the AIA, but they're weighted towards the contractor. I don't like the consensus docs. Okay? There's also a set called the EJCDC contract set, which is the Engineers Joint Council Document Committee. That's like the Engineering Society, their standardized set. From my perspective, okay, the AIA contracts for design professionals are the best out there for a couple of reasons. Number one, it's my belief, and a lot of attorneys in the industry, those that work with architects and engineers, believe that there's an equitable allocation of risk between everyone. Also, they've been around a long time. Every 10 years, the AIA set gets revised. Okay, and so the document set has been tested by the courts, which means that the language that's in there is predictable. So if you're going to, like, let's assume it's an owner-driven contract, always buyer beware, because it's always going to be drafted in the owner's best interest, and the language in there may or may not hold up in court, or we may not know truly what the implications are of the language because it hasn't been tested before. So we always promote, and a lot of the insurance companies and a lot of the attorneys that are in the industry, they promote the AIA document set, okay? The other thing that, and I don't want to go into contracts too, I'm going to stop there because we can come back and speak more about that. Any other questions or, yes?
Consultants,
Yep.
consultants that are contracted with us.
Yep.
What is our liability?
Let me tell you what your liability is. One of our biggest lawsuit claims in recent, and it was just settled about a year ago. Okay, there was an $80 million fire. The owner had $55 million of insurance. Okay, and so the insurance company subrogated against my clients, and the owner went against my client to pick up some of the delta. Okay, now this is a joint venture project. I'll explain what that is. You have two architects. They're joined at the hip. It's called a joint venture. It's a legal entity. It's a very large project, hotel casino in Atlantic City. It's been, at this point, it's been built for many years, okay? It was a joint venture. One of the design firms hired an envelope consultant. The owner, when it was going into construction, said, or the contractor said, you know what? You could save $20 million if you make the skin from a fire retardant to a non-fire retardant skin. That request went to the envelope consultant. He said, yes, it met code, no problem. Well, when it was under construction, it was alleged that there was arson. And a little fire that was supposed to be contained created $80 million worth of damage. The envelope consultant only had $1 million worth of insurance. So when you hire a consultant, you are what's known as vicariously responsible for what they did. Okay? So they only had $1 million of insurance. Each of these guys had $5 million. So because it was alleged arson, and because, quite frankly, the firms that were defending our clients did a really good job, they only paid $3 million each. Only. Now, here's the owner, actually. This is the owner here. So what happened was, one of the firms hired the envelope consultant. They had $1 million of insurance. There was a delta of about $25 million. So these guys each paid $3 million, and they paid $1 million. The envelope consultant just said, here. So when you're hiring a consultant, you want to make sure they have, quote unquote, appropriate insurance. Okay, one of our programs is called Controlling the Sub-Consultant Relationship. Most firms don't realize the potential implications of hiring a sub-consultant. So you really want to be careful about the types of sub-consultants that you're hiring, like geotech you don't want. Civil you probably don't want, but you may do it anyway. Landscape, surveying, not so bad, but when they make a mistake, it's always a problem when a building is a foot over the, but you know what I mean? That's always a problem, we've seen that. So there's certain kinds of consultants that technically in the industry have more exposure than others just because of the nature of what they do, you know? So you want to be careful. You want to also, now remember there are contracts here. In every relationship in this industry, there's a contract. Can anyone tell me why the industry uses a contract? It's because technically the expectation is static. Once the contract is signed, those responsibilities and expectations in the contract never change. The owner's expectations can completely change by the end of the project. So when there's a dispute or an issue comes up or there's a change, you go back to the contract and you say, okay, who's responsible for what? How are we going to deal with change? What's the payment scenario? If there's a dispute, the first thing your attorney is going to ask for is a copy of your contract. Who's responsible for what? So when you're involved with hiring subconsultants, I'm just gonna draw this here. You always want to control the contracts. Always, always, always. We'll say here, because you do engineering. This is the owner. I know you can't read my handwriting. This is the owner. Can anyone tell me what this is called? Have you seen this before?
Responsibility chart?
It's called traditional project delivery. 99% of your projects probably look like this. Or it's known as design, bid, build. Okay? This is how all your projects, almost the lion's share of your projects are set up. And so between each of these groups, there are contracts, okay? So between your firm, you're providing MEP and architecture, you're gonna have a contract with the owner. And you're gonna say, okay, we're gonna hire structural, okay? So you're gonna hire a structural. And then you're gonna hire landscape or whatever it might be. That's really bad handwriting. But anyway, so there's always gonna be a contract, or there should be a contract, between each of the parties, between you and the owner, between you and your sub. Your firm always wants to provide the sub-consultant agreement. You don't have to listen to me, but I'd prefer, I'll say it this way, I'd prefer if you don't take the sub-consultant's agreement and sign it. Because you don't know what's in the sub-consultant agreement. There could be who here has ever bought a dishwasher? And you get a bill, right? And you turn it over and there's all this little language. You know, like you're listening to the radio and they're selling a car and it goes blah, 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 right? Well, when you're taking a contract from your sub, you don't know what's in there. We had a situation a couple years ago. It was a civil engineering firm and they hired a sub-consultant. They were doing a site plan for an owner, developer. So our civil firm was here and they hired, I'm gonna say a little guy. It was a $5,000 fee for a wetlands delineation, $5,000 fee. About a year before I started doing business with them, they signed the agreement, okay, in order to provide the services for the owner, the site plan and the whole thing. Well, turns out that this agreement here, because it was the sub-consultant's agreement, had language in there that said, our liability is limited to our fee, and it said that our client, who is a civil, the prime, was responsible for their negligence. It was horrible. It was crazy. And I found out about this after the fact. And by the way, and this is what happened. The wetlands firm, they mislabeled a river. And so a well that went in one area now had to be moved to another area to the tune of $475,000. Meanwhile, the people that made a mistake were limited to $5,000. It was ugly. Ultimately, through a whole bunch of legal maneuvering, they ended up basically splitting the cost. But you see, the point is, you never want anyone to be in a better situation. You never want your sub contractually to be in a better position than you are, ever. That's like a rule of thumb. That's my rule of thumb. Okay? Any other questions?
Just for 1 second, can you talk about indemnification clause?
Absolutely. Okay. Now, in many contracts, there's going to be, this is what happens. There are about 17 different sections of a typical AIA contract. You know, what's the scope? Who's the owner? What do you do during, schematics and DDs and CDs and bidding? And it's to talk about what your responsibilities are. A lot of your contracts are going to have something, a section in there called indemnification. The question is, what does that mean? Okay, so do you remember when I was talking about our legal system is based on the British common law? And if Steve were sitting was standing on a ladder, and I knock him over, I'm responsible to make him whole, right? That's what the concept of indemnification is. Indemnification means that if I do damage to someone, I'm gonna make them whole, no better, no worse. But here's the thing. Who here is married to a lawyer? Okay? Lawyers like to put all kinds of words in there that say something beyond that responsibility. So what's going to happen is you're going to see words such as, this is a typical phrase. We agree to indemnify, defend, and hold you harmless for claims arising out of our negligence. I'm just going to kind of just say that right there. An indemnification provision can be one sentence, it can be 3 pages long. The more words, the worse, okay? Because you don't know what it really means. Anyway, if it says, I indemnify you, I will defend you, and I will hold you harmless. What that means is I indemnify, I will pay you. Defend, which is always a bad word, which you talk about, means I will defend you, and hold you harmless, which means I won't hold you responsible for claims arising out of our firm's negligence. Now here's the thing, okay? And you should actually look at a contract and see what it says. But if you ever see the word defend, defend's not a good word. Because that means no matter what happens, your firm has a responsibility to defend the owner no matter what the situation is. Okay, you do a school. You're done with the project. 3 years later, there's a guy out there polishing a floor and a child slips on the floor. And the allegation against the owner is that wrong coefficient of friction, then maintain and operate the site, and the architect this and the owner that, right? If you have a contract that says we will indemnify you, defend, and hold you harmless. Defend means that you have to defend them, and insurance companies won't pay for their defense until you've been deemed at fault. Which means that you have a legal responsibility to defend them, but there's no funding behind it. So you really want to look at that kind of stuff. You should be aware of it. Now, there's certain times when your firm will agree to it. And that's okay, it's a business decision, but you have to be aware of what's going on, okay? So indemnification means if I hurt Steve, I have to make him whole. No more, no less, okay? Any other questions or general questions? All right. Listen, thank you. I really appreciate your time. It was a lot of fun. And if anything comes up, something doesn't look like whatever, give us a call, reach out to us. You get my number from Debbie, from Steve, and everyone have a great afternoon. Okay? Thanks.